This New Jersey carry case could reshape gun laws nationwide. If you've been following Koons v. Platkin, this is a major update you need to know about. On January 8th, a coalition of more than 20 state attorneys general filed a consolidated amicus curiae brief with the U.S. Court of Appeals for the Third Circuit, just weeks before the Banc oral arguments are scheduled for February 11th in Philadelphia. This brief directly challenges New Jersey's so-called sensitive places law, and it carries implications far beyond this state. This case is about New Jersey's post-Bruen carry law, specifically the provisions that ban lawful concealed carry in massive categories of public places: parks, beaches, restaurants serving alcohol, public gatherings, and more. A prior Third Circuit panel upheld much of that law. Now the full court is rehearing the case en banc, meaning all active judges will consider it. First, a quick explanation. Amicus curiae literally means friend of the court. It's not a party to the case, it's an outside entity, often states, organizations, or experts, asking permission to provide legal analysis the court should consider. When over 20 states file a joint amicus brief, that's not symbolic, it's a signal. The issue affects the entire country, not just New Jersey. The brief was filed by the Attorneys General of Idaho, Montana, and more than 20 other states, plus the Arizona legislature. These are states that have a direct interest in how sensitive places, or otherwise known, we know them as gun-free zones, laws are interpreted, because many states are now facing copy and paste legislation modeled after New York and New Jersey. Their position is clear. New Jersey's law goes far beyond anything historically recognized under the Second Amendment. In their brief, they argue multiple points. Bruen was ignored. The states argue that the Third Circuit panel failed to apply New York State Rifle and Pistol Association v. Bruen correctly. Bruen requires courts to look to founding era history and tradition, not modern policy preferences or generalized, quote, public safety arguments. According to this brief, New Jersey relied heavily on late 1800s and even early 1900s laws, many of which were local, territorial, or never enforced. That's exactly what Bruen warned the courts not to do. Sensitive places have limits. The brief systematically dismantles New Jersey's sensitive places claims. In this brief, the states argue there is no historical tradition supporting blanket bans on carry in public parks and beaches, permitted public gatherings, and bars and restaurants serving alcohol, for example. Schools and government buildings, historically recognized, but expanding sensitive places to nearly everywhere people go? The brief says that would effectively erase the right to public carry altogether, something the Supreme Court explicitly rejected. Reconstruction-era laws don't save New Jersey. New Jersey leaned heavily on Reconstruction-era statutes to justify its law. The states counter that many of those laws banned only concealed carry, not all carry. Also, they applied only to intoxicated individuals. Also were tied to hunting or property protection, not self-defense. And some were upheld under legal theories the Supreme Court has already rejected. In short, the historical analogies don't match, either in what they restricted or why. So what does this mean for New Jersey? For New Jersey residents, this brief strengthens the argument that the state's carry map is constitutionally indefensible. If the Third Circuit adopts this reasoning, large portions of the sensitive places law could be struck down, restoring carry rights in everyday public spaces. So what are the national implications? This is bigger than New Jersey. Since Bruen, states like New York, New Jersey, California, and Hawaii have taken the same approach. If we can't deny permits, we'll ban carry everywhere instead. A strong en banc ruling here would send a clear message nationwide. You cannot nullify a constitutional right by redefining the entire state as sensitive. Oral arguments are scheduled for February 11th at 9:30 a.m. in Philadelphia. I'll be watching closely and I'll break down what happens, what questions the judges ask, and what that tells us about where this case is headed. If you want clear, legally grounded updates on carry law without the noise, make sure you're subscribed. This case will shape the future of public carry, not just in New Jersey, but across the country.